Thank you, everyone, for joining this briefing. My name is John Bonifaz. I'm the co-founder and president of Free Speech for People. We're pleased to be with you today to discuss this critical question, democracy under attack, how we fight back, with a special briefing on our current cases challenging voter suppression laws in Arizona and Texas, as well as our new campaign seeking to uphold Section 3 of the 14th Amendment, barring insurrectionists from any future ballot. This briefing is being recorded for the initial presentations. We will then have a Q&A session after that, and we'll explain to those who are interested in asking a question or making a comment how you can do that. We have been engaged, as many of you know, at Free Speech for People for more than a decade in fighting to defend our democracy and our Constitution. Last year, we engaged in a series of critical cases seeking to protect the right to vote and the election, leading to important victories prior to the November 2020 election. Today, we're continuing that fight, and we'll be talking about our cases challenging new voter suppression laws in Arizona and Texas, as well as a new campaign under Section 3 of the 14th Amendment to uphold that provision, barring insurrectionists from any future ballot. I'm joined today by Courtney Hostetler, our senior counsel, and Ron Fine, our legal director. Oski Buckley, our director of administration and finance, will be on hand to help us talk through having your questions posed. We're going to start with Courtney Hostetler, our senior counsel, on our Arizona and Texas cases. And thank you all for being with us.
Hi, everyone. I'm really glad to be here with you today and to talk about our work, as John said, in Texas and Arizona. 1 year ago, we were, just coming out of the November 2020 election. And what we saw was that even as the pandemic surged in many states, we saw an increase in voter turnout, and even more importantly, an increase in voter turnout amongst voters of color, amongst voters from traditionally marginalized communities, amongst new and intermittent voters. Many voters benefited from expanded voting opportunities that had been offered to them, like voting by mail. But many other voters voted despite barriers that they have faced in the past and continued to face. Unfortunately, instead of celebrating this enormous victory for our democracy, this increased voter turnout, and this excitement amongst new voters, some legislatures responded by passing voter suppression laws that will make it difficult for people to vote, that will roll back policies that made voting accessible, to make voting more inaccessible in places where it was already challenging to vote. And many of these laws are specifically going to burden Black, Latino, and Indigenous voters. And we're challenging two such laws, or laws in two states, in Arizona and in Texas. In Arizona, we're working with Pro Bono Counsel Mayor Brown and local Pro Bono Counsel Quarles and Brady to represent some truly outstanding civic engagement and voter education organizations: Mi Familia Vota, Living United for Change in Arizona, Arizona Coalition for Change, and Chispa Arizona, in challenging two voter suppression laws that were passed by a partisan vote earlier this year. Both of them affect the voting by mail program that Arizona offers. So for 30 years in Arizona, as a little bit of background, Arizona has actually offered no excuse voting as an option for their voters. And this is an option, no excuse voting by mail, excuse me. And it's an option that many voters have relied upon to cast their votes in increasing numbers over the last decade or so in particular. In 2010, well over half of Arizona voters chose to vote by mail. In 2016, that number jumped to 80% of Arizona voters. And then this past year, Arizona experienced its highest voter turnout and overall an increase both in the numbers and the percentage of voters who voted by mail. Voters of color were disproportionately likely to be new voters in Arizona in 2020, and they were disproportionately likely to vote early by mail. But again, instead of celebrating this as a success story, the legislature actually passed 2 laws that are going to make voting by mail difficult for many of its Black, Latino, and Indigenous voters. So the first is SB 1485. And what it does is it mandates purges of Arizona's permanent early voting list. Right now, or until this law was passed, any registered voter in Arizona could elect to automatically receive a mail-in ballot each election. So this means they don't need to apply for a mail-in ballot every time. It'll just come automatically to them. It's a hugely popular list that allows many thousands of voters to vote each year. And it particularly will benefit voters who are limited in time, who don't have access to voting in person, either due to the distance it takes to get to a polling place, work obligations, or other challenges. What this law will do is it'll purge that list of any voter who misses 2 elections. So current estimates suggest that the law could purge 150,000 voters from the list when it goes into effect. The law also will mandate this be a rolling process. So it's not going to happen once. It means any time that somebody misses, say, a local and a midterm election, they risk being purged and not receiving their mail-in ballot before the next election. The law does require that voters be given notice, but there's a lot of issues about how successful this notice will be, particularly complicated by issues such as voters who don't have stable access to mail, language barriers, and even if they get the notice, many voters will face enormous burdens just in being able to respond to that notice in a timely manner. It puts a really close time limit on how long a voter has to respond to the notice before they're stripped of their rights to be on this permanent early voting list. The second law is SB 1003. And again, it really challenges voting by mail. Right now, Arizona law requires voters to sign their mail-in ballots. If somebody is alleged to have a mismatched signature, so that's when an election officer compares the signature and decides that it doesn't match some signature that's on file. At least those voters are given 5 days after an election day to cure the ballot. And the way that they do this is they have to come into an election office during regular working hours to demonstrate that the ballot is their own. If somebody forgets to sign their ballot, or if they don't realize they were required to sign it, under this new law, they don't get those 5 days. They would have to cure by election day. There's no obligation that they be notified of the defect, so they might not even know that their ballot is about to be rejected. But even if they learn of this defect in time, there's a really difficult burden placed on them in just trying to get to an election office. An election office is not a polling place. It's not like they can just walk down to their local polling place. They would have to get into a county election office, again, during normal working hours. And often these offices aren't accessible. For voters who live on reservations, the offices can be dozens, even hundreds of miles away. But even for voters who might be lucky enough to have a county election office in their own city, it doesn't mean it's accessible. We did some research and saw that many voters could have to travel upwards of an hour or more to get to an office via public transportation. And really, this puts the opportunity to cure out of reach of many voters who need to work those hours, who can't afford to lose their wages if they work on an hourly wage, who might have obligations that keep them from being able to take 1, 2, 3 or more hours out of their day. And again, that's if they receive this notice in the first place. Unfortunately, what's going to happen is these laws are going to work in tandem to burden voters and place substantially greater burdens on voters of color who already face steep barriers to voting access, particularly for voting in person, which is why this voting by mail program is so critical to many voters in Arizona. So what we saw is that supporters of the bill, they voiced these baseless claims of fraud. But that happened even as Arizona election officials confirmed that there was no incident of widespread fraud, not only in this past election, but in any of the elections that have taken place in the 30-year history of Arizona offering this vote by mail system. The bill's own sponsors couldn't identify any incident of mail-in voter fraud. And really, these laws aren't going to prevent fraud. They're really disconnected. Unfortunately, as we've seen, fraud has become the go-to excuse that legislators use when they need a pretext for voter suppression, right? It's become that code word. When they want to suppress the vote, they look to the word fraud. An Arizona representative, John Kavanaugh, admitted in a public interview that he believes everybody shouldn't be voting, and I'm quoting him here. And while, quote, quantity of votes is important, but we have to look at the quality of votes as well. And it's really clear that he thinks that some of the new voters in Arizona, the voters of color in Arizona, the new voters in Arizona, aren't the quality of votes that he wants. And the goal was to suppress these voters from getting back to the polls in the future. It's unfortunately clear that the laws were passed not to secure elections, but to limit access to the polls and to keep legitimate voters from being able to vote. So we've challenged the constitutionality of these laws under the First, 14th, and 15th Amendments of the Constitution, and have also alleged that the laws violate the Voting Rights Act by intentionally discriminating against voters on the basis of race. After filing the lawsuit, both the Republican National Committee and the Democratic National Committee sought and were granted intervention. So we will be working with the DNC, who sought intervention on behalf of the plaintiffs, as we advocate for our clients. We have also brought a second lawsuit in Texas to challenge an omnibus voter suppression law there, SB 1, that was pushed through in a second special session held by the Texas legislature over this past summer. We are again representing Mi Familia Vota. Mi Familia Vota is a fantastic civic engagement organization that is active in a number of states in our country, both in Arizona and Texas being two of those. We're also representing several individual plaintiffs who are going to be harmed by this law. We're working with pro bono counsel Stoll Rivs and local pro bono counsel Lions and Lions. Our cases actually there been consolidated with several other cases that are also challenging SB 1. And the Department of Justice recently filed suit against Texas over this law as well. We are very committed to aggressively protecting the interests of our clients and making sure that we're challenging the many facets of this bill that are going to undermine voting rights in Texas. SB 1 is a really dangerous law that is going to make it hard to vote in person and by mail in Texas. It is also being placed on a voting system that is already inaccessible and burdensome, particularly for voters of color. Texas maintains an excuse-only mail-in voting system that substantially limits who can vote by mail, and it also requires eligible voters to go through a lengthy process to apply for and obtain their mail-in ballot each election. Texas has also made it hard to vote in person. The state has substantially cut down on the number of in-person polling places that they offer. They have a countywide polling place program that has authorized counties throughout the state to shutter 50% of their polling places. Between 2012 and 2018, even as the population of Texas grew, more than 750 polling places were closed, the vast majority of these being in communities that served people of color. More polling places have closed since then, as new large counties have joined the program and shut polling locations. Texas has also repeatedly tied the hands of local election officials who attempt to make voting accessible for voters. In 2019, just a few months before this pandemic began, the state passed a law that outlawed mobile early voting locations. This was a really important program that allowed resource-strapped counties to bring early voting to people who don't have access to early voting or election day sites. Then during the pandemic, Texas sued Harris County for trying to expand mail-in voting and made it generally difficult for counties to try to protect their citizens while maintaining accessible voting. Some counties, including Harris County, found innovative ways to make voting accessible despite Despite this, they, during the pandemic, expanded the use of curbside voting, offered 24-hour voting, and offered drive-through voting. And the result was literally hundreds of thousands of voters were able to get to the polls where ordinarily they would have been shut out. What SB 1 does is it does away with these options. It prohibits counties from offering 24-hour voting, prohibits counties from offering drive-through voting or from expanding curbside voting. It places strict limits on when polling places can be open, both on election day and during the early voting period. It prohibits counties from taking action to make voting accessible during unexpected disasters, be it the ongoing pandemic or a hurricane. It also prohibits counties from even providing mail-in ballot applications to eligible voters. So they can't even get the applications sent out. It also makes it easier for election officials to toss mail-in ballots. Previously, signature matching could only look back 6 years. So a signature had to be signed within the past 6 years for it to be compared to the ballot. Now, an election official can compare the signature on a ballot to any signature on file from that voter, which means somebody's ballot could be rejected because an untrained election official thinks that a signature from this past year doesn't match something that's on file from 30 years ago, or maybe that's on file but was signed before the person began to experience a disability. That is the reason they are allowed to vote by mail now. Counties aren't obligated to provide notice to people when their ballots are rejected, and curing the ballots is a difficult and burdensome process. The law also makes it really difficult for people who need physical and language assistance to vote from getting that assistance. People who provide assistance voluntarily are now required to sign oaths and provide personal information to poll workers, and they're subject to scrutiny by poll workers and poll watchers. There's limits on who can be in the car with you if you curbside vote. There's limits on what kind of assistance can be provided to you under this law. The law also requires counties to carry out monthly voter purges. Notably, a few years ago, after another surge in 2018, a surge in voting in Texas, the Secretary of State carried out a quote unquote purge and claimed that they identified more than 180,000 unlawful voters. As it turns out, that claim was false. Everybody they named was a naturalized citizen. At the time, they all remained they were able to continue to vote and remain on the voter polls because the Secretary of State hadn't been able to, as it turned, they were accurate and authorized voters. But now, under the new law, the burden is now going to be placed on voters. So if they are accused of not being a lawfully registered voter, then they will now have to jump through a number of hoops to prove their identity. And this is going to be a burden that no other voter is subject to. So if they are accused in these monthly voter purges of not being a naturalized citizen, of being an unlawful voter, if they're not able to jump through these hoops in a very limited amount of time, they're off and they don't get to vote. Again, this is not a burden that other voters are going to be subject to. And then finally, on this long list of ways the vote will be suppressed in Texas under this law, the law also opens the door to increased voter intimidation. It gives poll watchers more freedom to move around polling places and counting locations, to look over voters, to observe their assistants. And it really ties the hands of poll workers who might want to protect voters and themselves from intimidation. As we saw in Arizona and as we've seen elsewhere, supporters of the bill cited baseless claims of voter fraud. There was no such fraud found in the 2020 elections per Texas's own election officials. SB 1 doesn't do anything to prevent fraud. For example, people who vote with assistance or who vote via drive-through voting or curbside voting or extended hours are subject to the same requirements as any other voter. There's no reason why somebody who needs to vote after their shift ends at 10 o'clock at night or who needs language assistance to vote should be stopped from doing so. But that's exactly what this law does. Unfortunately, this law was passed. It's another example of how some legislatures have responded to increased voter turnout, particularly amongst new voters and voters of color. We've challenged the law. It's unconstitutional. It places an undue burden on the right to vote. violating the First, 14th, and 15th Amendments. It also violates Section 2 of the Voting Rights Act by intentionally discriminating against voters on the basis of race. And it violates Section 208 of the Voting Rights Act by depriving voters of language and physical assistance that they may need in order to vote. And what we've seen in both these states is, again, instead of celebrating increased voter turnout, and instead of celebrating the fact that our electorate has begun to better reflect the diversity of our country's voters and their needs and their interests and their goals, laws like the ones that we're challenging in Texas and Arizona are undermining these rights, are undermining the voting rights, they're harming our democracy. We are committed to aggressively representing our clients in challenging these harmful, unconstitutional laws, and will, of course, be looking for ongoing opportunities for us to protect voters in this country.
Thank you, Courtney. And we have a very short video to show you that discusses our Texas case, and Oski will cue that up, and then we'll go to Ron Fine, our legal director, for the next presentation.
Governor Greg Abbott signing some of the most sweeping voting restrictions in the country. The new law bans drive-through voting and 24-hour polling locations, which have increased turnout among minorities.
Texas Republicans are not doing this to stop voter fraud. They're doing this to stop people of color from voting.
SB 1, which is the law that passed, is really an omnibus piece of voter suppression and voter intimidation legislation. It prohibits 24-hour voting and it prohibits drive-through voting. And there's no reason for this. It made voting accessible. And that is not something the Texas legislature is interested in making available, particularly in places like Harris County.
Texas is already one of the hardest states to vote in. We already have elections that are antiquated and have intentionally not progressed. This lawsuit and litigation is a tool that we have to fight back. One of our plaintiffs on the lawsuit is actually an individual who works 12-hour shifts, right? And they're a person that comes out of work really early in the morning. If we had 24-hour voting, that would probably be their preferred method of voting. These are people that are just so animated, that are contributing to our society, contributing to our state, and they want to be part of the decision-making process.
There's a number of provisions that threaten election officials with criminal offenses if they don't try to suppress voters and target voters. Telling poll workers that they're not allowed to intervene when poll watchers begin intimidating voters has nothing to do with fraud. That absolutely is just giving a green light to people who are going to make it terrifying to vote in Texas.
Texas has drastically changed in the past few decades. We're battling a lot of narratives of what Texas is. We're not a state where only a certain demographic votes. We're not a state where only a certain demographic lives. We're a diverse, young state looking for different opportunities, wanting economic growth and mobility. And we're just not willing to take a lot of the attacks anymore.
Thank you, Oski. So our next presentation is from Ron Fine, our legal director, who will be discussing our 14.3 campaign. Ron?
Thank you. So 14.3 is the short name we've given to Section 3 of the 14th Amendment. And I'm going to talk briefly about what Section 3 of the 14th Amendment is, what it has to do with the January 6th insurrection, how it's enforced or implemented, and our campaign. So the first thing to know about 14.3 is that until quite recently, it was considered an obscure provision of the Constitution, but it was extremely important in the days following the Civil War when it was enacted. So this is the 14th Amendment, as you see. And what happened in 1865, after the end of the Civil War, is that a number of ex-Confederate officials, including the former Vice President of the Confederacy, several members of the Confederate Senate and the Confederate House, and even military officers of the Confederate Army showed up in Washington, D.C., in Senate and Congress, and expected to take their seats. And the Republicans in Congress were furious that these rebels should be able to just return into power and be able to undermine all that the Reconstruction effort was trying to do. And so they decided through the Joint Committee on Reconstruction to pass the 14th Amendment to form the new path for how the government would work. And the most famous provision of the 14th Amendment nowadays is part of Section 1, which talks about equal protection of the laws. But at the time, Section 3 was considered equally, if not more important. And that's what we're going to talk about right now. So if you'll direct your eyes to the bottom of the page, there you go. This is an easier to read format of it. And in fact, Oski, if you could even advance to the next slide, I think we can really zoom in on the relevant language, especially when we're talking about President Trump. What this says is no person shall hold any office, civil or military, under the United States who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same. So there are a couple of important moving parts in this. The reference to any office, civil or military, under the United States includes the presidency. Having previously taken an oath makes clear this applies to people who swore to defend the Constitution and then deliberately violated that oath. And the test of what would excludes them from eligibility for future office is having engaged in insurrection or rebellion. And those are terms that are not specifically defined in this amendment, but an insurrection basically means a conspiracy to overthrow the government by force or violence. So, Oski, I think you can put that slide away now. And I want to talk a little bit about how 14.3 is implemented or enforced. And what we do know is from the history of Reconstruction, for the few years after the Civil War, that Congress and to a lesser extent, the executive branch actually applied these provisions, that 14.3 was implemented in a wide variety of circumstances. It never required a conviction of a crime as a prerequisite. We've got evidence of cases in one North Carolina case, someone who had been elected as sheriff was denied that office, and the evidence was that he'd served as sheriff under the Confederate government. He was not convicted of a crime, but he had served on the rebellious side. We also know that you don't need a specific implementing act from Congress, because for the first few years after the 14th Amendment was passed, it was implemented and enforced, even though there was no implementing federal legislation. So what we do know, though, is that congressional action would be useful in this case, but not necessary. When I say this case, I'm talking about the storming of the Capitol. And that was an insurrection because it was an attempt to use force to disrupt the peaceful transfer of power, to overthrow the government by preventing the lawfully elected administration from ever taking power. And the questions that are before us then have to do with facts and who gets to apply them. So let's talk briefly about Congress and then our effort. So the amendment does not require specific congressional action, and there's no constitutional prerequisite in the text, and it wasn't used historically. However, it would be helpful. The 2021 article of impeachment that the House passed against Trump did cite incitement of insurrection as the ground. A majority of the House and a majority of the Senate voted for that. And in February, Free Speech for People and a broad coalition of legal and advocacy organizations sent a letter to Senate Majority Leader Schumer, and we urged Congress to pass legislation to do two things. One would be to issue findings and a sense of the Congress that President Trump and others had fallen within the scope of Section 3 of the 14th Amendment and were ineligible for future office. And the second thing was to establish a formal mechanism in the federal court system for ascertaining exactly who was subject to this. That legislation, if it were to happen, would be useful. It does not appear that it's happening anytime soon. There have been a few House bills that have been introduced from Representatives Steve Cohen, Cori Bush, Eleanor Holmes Norton, and others, but they have stalled in committee in the House, and nothing appears to be happening in the Senate. Rather, Congress's approach at this point seems to rely totally on the January 6th Select Committee. And while that committee has done some good work, it doesn't seem to reflect the urgency of the moment. And more importantly, the House of Representatives, or Congress generally, is not the only constitutional actor that is charged with applying the 14th Amendment. That's because the Constitution is presumed to be what lawyers call self-executing. That means that with a few very rare exceptions where a provision of the Constitution specifically says that it needs congressional action, other than that, the Constitution applies to all federal and state officials who are using their legal authority at all relevant times. So for example, equal protection of the laws in Section 1 of the 14th Amendment, you don't need a special congressional statute to require different types of local, state, or federal officials to apply equal protection of the laws. That's required by virtue of the 14th Amendment itself. And same for Section 3 of the 14th Amendment. And in fact, the history after the Civil War shows that 14.3 was enforced by all types of different officials, including local county boards of commissioners, local superior court judges, local district attorneys, in one case, a federal prosecutor, state legislatures, and in some cases, Congress itself. That's the model that we're using for our campaign. This past summer, we wrote letters to the top election officials of all 50 states, plus the District of Columbia. In most cases, the recipients were secretaries of state. In some cases, they were state boards of elections. And we noted in these letters that election officials have sworn an oath to support and defend the Constitution. And it is not uncommon for people who are constitutionally ineligible for the office of president or any other office to file paperwork to run for that office. And state elections officials have often ruled that someone who is ineligible for an office can't appear on the ballot. So for example, the Constitution specifies a minimum age of 35 to be president. And in California, there was a case where a woman who was in her mid-20s filed paperwork to run for president. And the California Secretary of State just said, no, you can't be on the ballot. You're ineligible to hold the office. You're ineligible to appear on the ballot. She sued and she lost. Similarly, in Colorado, a foreign-born individual filed to run for president, and the Colorado Secretary of State said, no, you're not a natural-born citizen. He sued, he lost. The judge who wrote the opinion explaining why he lost was Judge Neil Gorsuch, now of the US Supreme Court, who explained that state elections officials certainly have the authority to exclude someone from the ballot for president if they are ineligible to actually hold the office of president. So in our letters to these officials, we cited not only federal constitutional principles, but in most cases, specific state laws and precedents that supported the state officials' authority and obligation to exclude Trump and any other insurrectionists who run for federal office from the ballot. That's because the Constitution is the supreme law of the land. And these officials have taken an oath to support it. No further state implementing legislation is needed to instruct them to act consistently with the US Constitution. They've already taken an oath of office to do that. And allowing a known insurrectionist to appear on the ballot is inconsistent with that obligation. A question you may ask is, why did we launch this campaign now in 2021? Why are we starting so far ahead of the 2024 election when Trump has made it pretty clear that he's running in 2024? So the answer is we can't file a formal ballot challenge to Trump's eligibility yet, simply because he hasn't formally declared and the 2024 cycle hasn't legally begun. But obviously this is happening and it's going to be a controversial issue. In 2020, and for that matter, going back to Bush v. Gore, there's been a pattern of novel, high-stakes election law issues being addressed for the first time under the white-hot heat and light of incredibly urgent, tight time frame litigation in the middle of an election or shortly after it. We think it's important that rather than wait until the urgency of an impending election, state elections officials begin to address this critical issue now. And that's why we've launched the 14.3 campaign. It's obviously in the early stages, but as we get closer to the 2022 election, and then ultimately to the 2024 election, we're going to be doing more and more to insist that state elections officials uphold their duties to protect the country from insurrectionists again holding high office. Thank you.
Thank you, Ron. We also have a short video on this campaign that Oski will queue up and show us, and then we'll go to questions and answers.
Considering a run for President of the United States? The U.S. Constitution sets a few guidelines. You must be at least 35 years of age, you must be a natural-born citizen of the United States and a resident for at least 14 years. And you cannot take an oath to protect the Constitution and then incite a violent insurrection.
We will never give up. We will never concede. We're going to walk down to the Capitol, and if you don't fight like hell, you're not going to have a country anymore.
By inciting a violent attack on Congress in an effort to prevent the certification of his own electoral defeat, Donald Trump engaged in insurrection and violated his oath of office. According to the U.S. Constitution, this makes him ineligible to run for future office. Section 3 of the 14th Amendment, passed in the aftermath of the Civil War, disqualifies from public office any individual who has taken an oath to uphold the Constitution and then engages in insurrection or rebellion against the United States, or gives aid and comfort to those who do. Donald Trump's words and actions incited a violent assault on our nation's capital. 5 Americans died, and more than 140 officers were injured. Free Speech for People is making clear to secretaries of state and chief election officials across the country that they must follow the mandate of Section 3 of the 14th Amendment and bar Trump from the ballot in 2024.